Hello and welcome to another episode of the Lone Wolf Pack podcast. I'm your host, Equity Ed, here to guide you through the fascinating and often complex world of law. Today, we're diving into a subject that's as rich in history as it is in practical significance, equity and attachment. Now, before you think this is just another dry legal topic, let me assure you it's anything but. We'll be breaking down these concepts with detailed explanations, intriguing historical insights, and even a bit of legal humor to keep things interesting. But first, let me remind you of something important. The information we're covering today is for educational purposes only and should not be taken as legal advice. If you've got a specific legal issue, be sure to consult a professional who can provide guidance tailored to your situation. All right, with that out of the way, let's dive into the world of equity and attachment, definition and purpose of attachment. So, what exactly is attachment? At its core, attachment is a legal process where a court orders the seizure of a defendant's property to secure the satisfaction of a potential judgment. Imagine it as the court putting a lock on someone's assets, ensuring that they can't just disappear with the wind before a judgment is rendered. It's a way to make sure that, should the plaintiff win, there will be assets available to satisfy the judgment. Let's break this down with some definitions from the heavy hitters of legal dictionaries. Anderson's 1887 Law Dictionary defines attachment as the act or process of taking, apprehending, or seizing persons or property by virtue of a writ, summons, or other judicial order. In simpler terms, it's the court's way of saying, hold on, we're going to need to keep an eye on these assets until we figure out what's what. Now, according to Bouvier's Law Dictionary, attachment is a remedy by which a plaintiff is enabled to acquire a lien upon the property or effects of his debtor in advance of obtaining judgment and execution. What does this mean? Essentially, even before the court has made a decision, the plaintiff can ask the court to lock down the defendant's assets, making sure they don't vanish into thin air. And last but certainly not least, Black's Law Dictionary, 2nd edition, gives us a slightly different take. It defines attachment as the legal process of seizing property to ensure satisfaction of a judgment which the plaintiff may obtain in an action. Notice the key phrase here, may obtain. The court isn't presuming the plaintiff will win, but it's making sure that if they do, there will be assets available to satisfy that judgment. But attachment isn't just about grabbing assets, it's about ensuring fairness. This is where equity comes into play. Equity is that branch of law that steps in when the strict application of the rules might lead to an unjust result. Think of equity as the wise, older sibling of the legal system, always looking out for what's fair and just, even when the letter of the law might suggest otherwise. 2. Historical background in equity jurisprudence. Now let's take a step back in time to understand where attachment comes from. Historically, attachment developed as a remedy in equity when common law remedies were too rigid to address certain injustices. The concept has deep roots in the history of equity jurisprudence, evolving over centuries to become the vital legal tool it is today. Equity courts, also known as courts of chancery, were established to provide relief in situations where the common law was too strict or didn't offer a solution. These courts were often presided over by the chancellor, a figure who wielded considerable power and was tasked with ensuring that justice was done, even if it meant bending the usual rules. Imagine this scenario. In medieval England, a debtor, knowing full well they owe money, starts transferring assets out of the jurisdiction to avoid paying up. The common law courts might shrug their shoulders, but the equity courts, they have no patience for such games. The equity court could issue an attachment, effectively freezing those assets and making sure they're available to satisfy any judgment that might be handed down. Here's a fascinating historical tidbit. During the 17th and 18th centuries in England, the courts of chancery became the go-to place for those seeking justice when the common law courts offered no solution. These courts recognize the need to protect plaintiffs from defendants who might try to evade justice by transferring or hiding assets. The attachment process became a crucial tool in these situations, ensuring that justice wasn't just a concept, but a reality. This practice wasn't limited to England. As the concept of equity spread to other common law jurisdictions, the use of attachment as a legal remedy became a staple in ensuring that defendants couldn't simply outmaneuver the legal system by hiding or moving their assets. It's a prime example of how the principles of equity were used to fill the gaps left by the rigidity of common law. 3. Grounds for attachment. So now that we know what attachment is and where it comes from, let's talk about the grounds for seeking an attachment. The legal basis for attachment is usually rooted in statutory law. These are laws passed by legislatures that spell out the conditions under which attachment can be granted. But what happens when the statute doesn't quite cover a specific situation? That's where equity steps in. For instance, a statute might allow for attachment in clear-cut cases of fraud where a defendant is obviously up to no good. But what if the defendant's actions are just fraud adjacent? Suspicious but not outright illegal? In these gray areas, equity's flexible principles can be applied to protect the plaintiff's rights, even when statutory law might not be up to the task. Here's how it works. The statutory law provides the framework, the basic rules of the game. But equity allows the court to adapt those rules to the specific circumstances of the case. For example, Black's Law Dictionary, 2nd edition, defines a statute as a law enacted by the legislative branch of a government. These statutes provide the legal foundation for attachment, but equity ensures that the law is applied fairly and justly, even when the strict language of the statute might not fully address the situation at hand. Equity isn't just about applying the law, it's about doing what's right. And when it comes to attachment, that means making sure that defendants can't use legal loopholes to dodge their responsibilities. IV. Equitable principles. Governing attachment. Equity operates on several key principles that guide how attachment is applied. Let's explore a couple of these principles in more detail. 1. Equity acts in personam. This principle means that equity deals with individuals, not just with property. In practice, this allows courts to enforce orders directly against a person rather than merely seizing their assets. Imagine you owe someone money and the court orders you to pay it back. Instead of just freezing your bank account, equity might use attachment to ensure that you fulfill your obligations. Historically, this principle was crucial in cases where simply seizing property wouldn't have been enough to ensure justice. For example, in 19th century England, equity courts often issued personal orders that required defendants to act in certain ways, with the threat of imprisonment if they didn't comply. It was a powerful tool. Think of it as the legal equivalent of saying, "We're going to make sure you do the right thing, or else." 2. Equality is equity. This principle ensures that all parties in an attachment proceeding are treated fairly. Imagine a scenario where multiple creditors are trying to attach the same piece of property. Equity steps in to ensure that the property is distributed fairly among the creditors, preventing one from gaining an unfair advantage. The concept of equity as a balancing force in legal proceedings has been a cornerstone of jurisprudence for centuries. It's about ensuring that justice is done in a way that is fair to all parties involved, not just the ones who are first in line. This principle is especially important in attachment cases where the stakes can be high and the potential for injustice is significant if the process isn't handled carefully. V. Procedure for obtaining an attachment. Now that we've covered the principles governing attachment, let's dive into the nuts and bolts of how you actually go about getting an attachment. The process isn't as simple as just asking for it. You've got to go through a formal procedure to convince the court that an attachment is necessary. Application process. The first step in obtaining an attachment is filing a petition with the court. This is a formal request where the plaintiff lays out the reasons why they believe an attachment is necessary. In equity, the plaintiff typically needs to show that they have no adequate remedy at law and that the defendant's actions pose a significant risk to their interests. For example, if a plaintiff fears that a defendant is about to transfer assets out of the jurisdiction to avoid paying a debt, the plaintiff must provide evidence of this risk. This could involve showing patterns of asset transfers or other behavior that suggests the defendant is trying to dodge responsibility. Equity requires more than just suspicion. It demands a substantial likelihood of harm without the attachment. Judicial considerations. Once the application is filed, the court doesn't just rubber stamp it. Instead, equity courts engage in a careful balancing act, weighing the interests of both the plaintiff and the defendant. This is where the balance of hardships comes into play, a concept that sounds straightforward but is rich with nuance. If granting the attachment would impose a significant burden on the defendant, say freezing their business accounts which could cripple their operations, the court might require the plaintiff to post a bond. This bond acts as insurance, compensating the defendant for any damages if the attachment later turns out to be unwarranted. It's like the court saying, "We'll allow this, but if it turns out you were wrong, you're going to have to pay for the trouble you caused." Historically, bonds were a common requirement in equity courts, ensuring that plaintiffs couldn't cavalierly request attachments without risking something themselves. This practice dates back to the early English courts of chancery, where the bond served as a check against frivolous claims. Notice and hearing requirements. One of the cornerstones of the legal process is due process, a concept that ensures fairness by requiring that all parties have a chance to present their side of the story. In attachment cases, this typically means that the defendant must be given notice and an opportunity to be heard before the court issues an attachment order. However, equity recognizes that in some urgent situations, giving prior notice could allow the defendant to outmaneuver the court, say by quickly moving assets out of reach. In these cases, courts might issue an ex parte attachment order, where the plaintiff can get the attachment without the defendant's prior knowledge. This might seem a bit like stacking the deck, but it's all about preventing immediate harm. The use of ex parte orders dates back centuries, often used in cases where delay could result in irreparable harm. However, even in these cases, courts would schedule a hearing shortly afterward to ensure that the defendant had a chance to contest the order. It's equity's way of saying, "We're not going to let you pull a fast one, but we'll give you your day in court soon enough." 6. Enforcement of attachment. Now that the attachment has been granted, the next step is enforcement. This is where the rubber meets the road, ensuring that the court's order is carried out effectively and fairly. Methods of enforcing an attachment. Once the court grants an attachment, enforcement typically falls to a sheriff or another designated court officer. This isn't just a procedural step, it's a critical part of ensuring that the attachment is carried out fairly and effectively. Imagine a sheriff arriving at a defendant's business with a court order in hand. The sheriff's job is to seize the specified property without causing unnecessary disruption. If the court ordered the attachment of a bank account, the sheriff ensures that only the funds in that account are frozen, leaving other accounts untouched. This level of precision is crucial in equity, where the goal is to balance the rights of both parties. Historically, the role of the sheriff in enforcing attachments was a powerful one, especially in cases involving large estates or significant assets. In 18th century England, for example, sheriffs were often tasked with seizing entire estates, from livestock to furniture, to satisfy attachment orders. The process was detailed and strict, ensuring that the court's orders were followed to the letter. Role of the sheriff or other officer in enforcing attachments. The court officer's role in enforcing an attachment is more than just administrative. It's about upholding the court's directive while protecting the defendant's rights. If the attachment involves seizing physical property, The officer must ensure that only the specified items are taken. This is crucial in preventing overreach, where more property than necessary might be seized. Take, for instance, a scenario where the court orders the attachment of a warehouse full of goods. The sheriff must inventory and secure only the goods specified in the order, leaving the rest untouched. This meticulous approach reflects equity's concern for fairness and precision in enforcement. Equitable limitations on enforcement. Equity doesn't stop at granting and enforcing attachments. It also places important limitations to protect the defendant's rights. Two key equitable maxims govern this aspect. 1. He who seeks equity must do equity. This principle requires the plaintiff to act fairly throughout the attachment process. If the plaintiff misleads the court or engages in unethical conduct to obtain an attachment, equity will step in to correct the situation. For example, if a plaintiff exaggerates the threat posed by the defendant to secure an attachment, the court could dissolve the attachment and deny further relief. 2. Protection of the debtor's rights. Equity courts are particularly vigilant in protecting the rights of debtors during attachment proceedings. For instance, if the court finds that the attachment is overly broad or causes undue hardship, it might limit the scope of the attachment to ensure that the defendant can still meet their basic needs. Imagine a scenario where a debtor's primary residence is attached. The court might allow the debtor to retain the property if it's necessary for their livelihood. 7. Release and dissolution of attachment. Now let's talk about what happens if an attachment is no longer necessary or if it turns out that the attachment was obtained improperly. This is where the concepts of release and dissolution come into play. Conditions for release. An attachment may be released if the defendant posts a bond or provides other security to assure the court of their intent to satisfy any future judgment. This option allows the defendant to regain control over their property while still protecting the plaintiff's interests. For example, if a defendant can demonstrate that they have sufficient assets to cover the judgment, the court might release the attachment to prevent unnecessary hardship. Historically, bonds played a crucial role in securing the release of attachments, particularly in cases involving significant financial stakes. In 19th century America, for instance, defendants often posted bonds as a way to avoid the immediate impact of an attachment while still providing security for the plaintiff's claims. Equitable grounds for dissolution. Equity provides several grounds on which an attachment may be dissolved, particularly when the plaintiff's conduct or circumstances surrounding the attachment warrant such relief. 1. Lachers. Lachers is an equitable doctrine that prevents a plaintiff from benefiting from an attachment if they have unreasonably delayed in seeking the remedy. For example, if a plaintiff knew of the defendant's actions threatening their interests but waited too long to seek an attachment, the court might dissolve the attachment on the grounds of laches. 2. Unclean hands. The doctrine of unclean hands prevents a plaintiff from obtaining or enforcing an attachment if they have acted in bad faith or engaged in inequitable conduct. For instance, if the plaintiff's primary motive for seeking attachment is to harass the defendant rather than protect legitimate interests, the court might dissolve the attachment and penalize the plaintiff. Yet, equitable remedies for wrongful attachment. Now, what happens if the court later determines that the attachment was wrongful? Equity provides a range of remedies to address this situation. Remedies available in equity. When an attachment is found to be wrongful, equity courts offer several remedies to address the harm suffered by the defendant. These remedies include the recovery of damages, where the court orders the plaintiff to compensate the defendant for any losses incurred due to the wrongful attachment. For example, if a defendant's business is harmed because of an unjustified attachment, the court might award damages to cover lost income and other related costs. Another potential remedy is the issuance of an injunction to prevent further harm, such as stopping the plaintiff from continuing to pursue the attachment. These remedies ensure that equity is maintained and that wrongful attachments do not go unchecked. Equitable estoppel as a defense. Equitable estoppel is a defense that can prevent a plaintiff from enforcing an attachment if their actions have misled the defendant to their detriment. For example, if a plaintiff assured the defendant that no attachment would be sought and the defendant relied on this assurance, the court might estop the plaintiff from proceeding with the attachment. This defense serves as a critical check on the misuse of attachment and other legal remedies, ensuring that equity remains a fair and just system of law. Examples of cases. 1. Case of wrongful attachment. In a historical case, a plaintiff obtained an attachment against a defendant's property based on false allegations of fraud. When the truth came to light, the court dissolved the attachment and awarded the defendant damages for the wrongful seizure of their property. This case highlights the importance of honesty in seeking attachment and the consequences of abusing this remedy. 2. Case of equitable estoppel. In another case, a plaintiff delayed seeking attachment while repeatedly assuring the defendant that no legal action would be taken. The defendant, relying on these assurances, made financial decisions that left them vulnerable when the plaintiff finally pursued attachment. The court, recognizing the plaintiff's inconsistent conduct, stopped them from enforcing the attachment, thus protecting the defendant from unfair harm. Conclusion. To wrap things up, let's reflect on the role that equity plays in attachment proceedings. Equity isn't just about following the rules, it's about ensuring that justice is done, that the process is fair, and that the rights of all parties are respected. Summary of the role of equity in attachment proceedings. Equity plays a crucial role in ensuring that attachment proceedings are conducted with fairness, integrity, and respect for the rights of all parties involved. Through principles such as "he who seeks equity must do equity," and doctrines like Lark's and unclean hands, equity courts provide a balanced approach to both the enforcement and dissolution of attachments. These principles ensure that attachment remains a tool for justice rather than a weapon for oppression. Final thoughts on the importance of equitable considerations in attachment. The equitable approach to attachment is vital for maintaining the integrity of the legal system. By emphasizing fairness, good faith, and the protection of all parties' rights, equity jurisprudence offers a nuanced and just framework for handling attachment cases. This approach ensures that attachment serves its intended purpose, securing potential judgments without causing undue harm or fostering injustice. As legal disputes continue to evolve, the principles of equity will remain essential in guiding the fair and effective use of attachment and other legal remedies. Remember, the law is not just about rules, it's about justice. That's all for today's episode of the Lone Wolf Pack podcast. I hope you found this deep dive into equity and attachment as fascinating as I did. Understanding these concepts is key to navigating the legal landscape with confidence and clarity. Thanks for joining me, Equity Ed, and until next time, stay sharp, stay informed, and always